My name is Andrea Evans, and I will be talking to you about trademarks. Intellectual property is divided into three parts: patents, trademarks, and copyrights. You would patent an invention, and then you would trademark the name of that invention, and you would copyright written materials. So, for example, you would patent a television, trademark Sony, the name of that television, and copyright written works. First, let's step back and discuss what can be trademarked. Words can be trademarked, sounds can be trademarked, scents can be trademarked, images can be trademarked, and even colors can be trademarked, provided that they serve as a source identifier. So that means that the public or consumers need to identify those symbols and sounds and words and those things that we just discussed that are eligible for trademark protection as a source identifier. They need to identify those with a particular brand for particular and specific goods and services. Now that you're clear that you can trademark words, symbols, sounds, images, you want to be sure that you're not just trying to protect your favorite word or your favorite color. What I mean by that is you are required to actually be intending to use those images and sounds and symbols and words on products or services, or actually be using them in commerce on goods and services. So you can't just protect your favorite expression. You can't just protect your favorite name. And I also want to be clear that just because you form a corporation doesn't mean that you own the trademark, and just because you own the trademark doesn't mean that you own the corporation. Now, another myth that often comes up is people assume that because they own the domain name, they own the rights in the trademark, and because they own the trademark, they own rights in the domain name. So that's not necessarily the case. If you are using a domain name or a hashtag or an image on a particular product or service, then you're eligible to protect that for a federal trademark. However, if you're using that sort of as an address bar or your address on the web, unfortunately, it won't qualify for a federal trademark. So here in the United States, you can file a trademark application as an intent to use application or a use application. And that's just what it sounds like. If you're intending to use the mark on particular goods and services, you'd file the application and let them know that you intend to use them. If you're actually using the mark on actual goods and services in interstate commerce, you'd identify the first date of use and the first date of use in interstate commerce that you've used the mark on those goods or services. Now, I'm going to talk to you briefly about the timeline of a U.S. application. Once you file a trademark application, in 3 months it's assigned to a trademark examining attorney at the USPTO. Once that USPTO examiner gets that application, they're going to look for informalities. Did you pay the fee? Are the identifications accurate? Is the mark filed properly? Is the owner identified? Essentially, they're looking to make sure that the application was filed correctly. Once they examine the application for informalities, then they plan to do a search. They're going to use a resource that you have access to, uspto.gov. You can go there and search your mark prior to filing to ensure that there's no other marks out there that are likely to cause confusion. Now, the standard for trademark registration is a likelihood of confusion. So the question is, are there other marks that are likely to cause confusion with your mark? So if there's a mark that's filed prior or a mark that's registered, essentially you may not be able to get that federal trademark. Now, more than one person can own the same name for a trademark. So my name can be Evans IP Law for a law firm, and your name could be Evans IP Law for a shoe company, because the public wouldn't necessarily perceive a shoe company and a law firm to be owned by the same entity. Now, the next thing that you want to think about when you think about a likelihood of confusion is the commercial impression of the marks. Do they sound the same? Do they look the same? Do they have the same meaning? Does it mean something in a foreign language that translates into a meaning of a word in English that's already trademarked? These are things that you want to think about and consider before you file an application. Now, when that trademark examining attorney does that search on uspto.gov and they're looking to see if there are marks that are confusingly similar, if they find that, you'll be issued an office action, and then you'll be given 6 months to respond to that office action. So you want to make sure that you're working with a qualified attorney to help you articulate arguments to show why your application and your mark does not cause any confusion. Provided that you can persuade them, then the mark is published in the official gazette for third parties to challenge. At that time, someone in the public who may perceive your mark as causing confusion or have an issue with your mark can then challenge you for 30 days. Provided they don't challenge you, then the mark will register. Now, once you get a trademark registration, keep in mind that it's up to you to police and enforce your trademark applications. As you're choosing the best name for your product or your service, you want to ensure that you choose a strong name. So there's actually a spectrum of trademarks from weak to strong. For instance, generic terms cannot be trademarked, so you cannot trademark the word shoes for shoes. And that makes sense because that wouldn't be fair for the government to give you exclusive rights to use a generic word. So as we move up the spectrum, we have descriptive terms. So descriptive terms describe a feature of your goods or services. So chocolate for chocolate covered candy, or maybe a description of hot and juicy for hot and juicy crawfish. Those are things that describe a feature of your goods. Now, those terms can be trademarked, but they're weak in the sense that others may actually use those terms in a descriptive manner to describe their particular goods and services. Now, as you're considering names, the strongest type of trademark is what we call a fanciful word. So that's a word that has no dictionary definition or meaning. For instance, Google. It doesn't mean anything in the dictionary, so it's a very strong word because they created that word. Then we move down the spectrum to arbitrary words that are very strong. So those are words that have dictionary meaning, but they have no meaning or any description or relation to the goods or services that you offer. Now, a good example of that would be Apple. Apple means something in the dictionary, but it doesn't have any meaning or relation to computers. So as you consider creating a name, the stronger the name, the more likely that you won't have any problems to register. And also, it would be easier for you to enforce because it's going to be a very strong word that you created. So you want to make sure that you create a strong brand and then prepare to police and enforce your brand. Now, I'm a U.S. intellectual property attorney, and I want you to be aware of the Madrid Protocol. So this protocol allows you to file an application, for instance, in Australia, and then designate the United States as one of the countries, and it simplifies the process because it allows you to then have Australia upload the information to the patent office on your behalf. Now, if you get issued an office action like we discussed, you then can contact a qualified U.S. patent or trademark attorney like myself to work with you to resolve any issues. There are several benefits of registering your trademark. First is that it puts others on notice that you own the rights in that name. So that's extremely important. Secondly, whatever you can do with real property, you can do with intellectual property. So just like you can sell your home, you could sell your trademark. You can license it, you can assign it, you can will it. So that can be extremely valuable as you leave a legacy for your family. Last but not least, trademarks are extremely valuable and important to protect. So I'd like to encourage you to take the necessary steps to protect your brands here in the United States as well as in Australia. I am a U.S. intellectual property attorney, so I have jurisdiction here in the United States, and I definitely recommend you seek the help of a qualified Australian attorney to help you to register in Australia. If I could be of any resource or help, I'd love to do so. Please feel free to contact me, and thank you for your time today.